absence program or sick parental and family care absence. Would just be consistent with that.
What is it currently?
Right now it's 1 year.
1 year.
The next topic I wanted to talk about, if there are no questions on that one, is the panel of physicians. The union had a proposal and talked about this during their testimony, that they wanted to remove the requirement to use the panel of physicians. And I wanted to talk briefly about that. PSCOA employees have been using panels since we first had a pilot program in the Philadelphia area. And that was back in 1994. I know that PSCOA did not represent them back then, but we had discussed the implementation of panels with the union that was representing them at the time, and worked with the union and all other unions to establish those panels. We redesigned the panels to provide better health care coverage, the ability to use panels in surrounding counties. In 2007, in December of that year, we provided information to the unions about that change and offered to discuss any changes with the panel, or with the union at that time about the panel providers. No contact was made by the union to discuss that with us. As for the makeup of the panels, we only use reputable doctors. They're doctors that are specializing in the treatment of injuries. Sometimes family doctors aren't as equipped to deal with acute injuries. And oftentimes we look for providers that can deal with that. We have chiropractors on our panels. We have orthopedic doctors on our panels that can deal with those more traumatic injuries when there's additional services needed. We also have first response type medical providers. There's a lot more of those that are showing up, where you can go in for emergency care, or you can use them as a primary care physician. We're moving towards a lot more of those. Rather than having an employee sit in an emergency room, those doctors are better equipped to see our employees quicker. And sometimes we even have employees that have their local primary care physician's office on the panel. We use a group of doctors to set up these panels that includes doctors that are agreeing to our network discounts. Under the workers' compensation law, there are there's a parameter in place that provides how much the doctor can bill us for a workers' comp injury. We have doctors that have agreed to a lower discount just to get our business. And again, we don't choose doctors that are just willing to take our business unless they're reputable. And we've saved the Commonwealth about $3.9 million, or a little more than that, in just 1 year's time frame by using these panel doctors. And then the last thing I wanted to just mention is that I'm not aware, I've checked with staff at Department of Corrections and at our workers' comp providers contacts. No one's aware of any issues that PSCOA has brought to our attention about a doctor. We have gotten issues about specific doctors in the past, specifically one that I remember from even as recent as 2 months ago. There was an issue with a particular provider that PennDOT raised with us, and we have since removed that doctor from the panel. They weren't providing the service to the employee or to the Commonwealth that we would expect. So if that happens, if the union ever wants to bring an issue to our attention, we'll be glad to look at that.
Any questions from the association?
Ma'am, I'm Ian Blinn. I'm an attorney. I represent the PSCOA. I do a lot of hard-won work on behalf of the PSCOA, and I have become aware of a number of instances where, for instance, an injured worker goes to occupational net or work net or one of these essential workers' comp factory places, and gets told, oh, well, your knee is a little swollen, put some ice on it, go back to work in 2 days. And then we'll go for a second opinion and find that he's got a torn medial meniscus, which is never going to heal without surgical intervention. That happens all the time. Are you aware of that?
Well, I have to look at the specific cases because I'm not aware of any kinds of problems that we're having. Like I said, the union hasn't brought any issues to our attention.
Well, okay. You mentioned that doctors will change their fee structure just to get your business, just to get on the panel.
Not necessarily. unilaterally, they've agreed to a fee structure that's lower than the discount provided by the Workers' Compensation Act.
Just to get your business.
They like to have the Commonwealth business. That helps with their business, surely.
And in Heart and Lung, there is no provision for these panel doctors, correct?
Within the Heart and Lung Act, it states that the employer is to provide health benefits, medical benefits, hospital benefits, and salary benefits.
Right. So
It doesn't say that we cannot use panels.
well, there is something in the Workers' Compensation Act that specifies the use of panel doctors, right?
That is correct.
Is there anything that specifies the use of panel doctors in the Heart and Lung Act?
No, it's silent on the issue. So the Commonwealth, as well as many other employers, have implemented panel positions for other groups that are represented and covered by the Heart and Lung Act.
And do you not recognize the inherent conflict of interest that those panel doctors have, where they are at least partially dependent on, for their income stream, upon the goodwill of the Commonwealth rather than the goodwill of their patient?
I disagree with you. All doctors take an oath when they're provided their license and become doctors. They're going to treat their patients. The workers' comp patient becomes their patient. They're going to be considerate of what the patient needs. They could have a malpractice suit if they're not, quite frankly.
I understand that they're supposed to be the injured worker's patient, but can't you see the inherent conflict of interest where the doctor is at least implicitly trying to please the Commonwealth because he wants to keep that business?
I disagree with you. They're not trying to please the Commonwealth. They're treating the injured worker because they're doctors, and that's what they've committed to do, to treat employees, injured workers, and other patients.
Well, let me ask you this. What good does it do the injured worker to have to go to a panel doctor?
Objection. Not sure how she can answer what good it does the injured worker.
Seems to be done pretty well. If you think you can answer it, go for it.
Well, as I mentioned earlier in my testimony, these doctors that we put on the panel are equipped to deal with work-related injuries. They are doctors that are used to dealing with more traumatic injuries. Sometimes primary care physicians get involved in lots of different types of medicine. And we believe that the doctors that we put on the panels are equipped to deal with any injured worker. If they're not, they can be referred to a specialist, and there are specialists on the panel as well.
If you got hurt, ma'am, would you like the government to tell you what doctor you have to see?
I would know that my employer has provided doctors that are equipped to handle my situation. Honestly, I would not go to my panel doctor if I was hurt with a back injury. I don't believe that my panel doctor would be a doctor that's equipped to deal with that. I would want to select from an orthopedic doctor in that case, or a chiropractor.
Well, there would be a list, presumably, which would include at least one orthopedic specialist.
That's correct, and the employee can choose if they want to
And
use.
do you want to go to that orthopedic specialist, or do you want to go to your own doctor?
I told you I would not go to my own doctor for a work-related injury, and I'm not just making that up.
Okay.
Ms. Kyrie, you said you wouldn't go to your own doctor, you'd rather go to a panel doctor. How many times have you suffered a work-related injury for which you had to seek medical treatment since 1994?
I have not had any work-related injuries, thankfully.
Thank you.
Thank you.
The next slide is the result of the Commonwealth's response to the Heart and Lung process that the union put forth. We had a meeting with the union the other day. We are still working together after getting up to a mutual understanding on how to develop the pre-hearing process so that when we actually have cases go forward on hearing days, there's notice, there's sharing of discovery, and there's no surprises. At this point, this is what we put forth in response to the unions, but we continue to be willing to sit down and work with them on developing this.
Okay, I know I already said it to you, Brian. I don't know if Attorney Green was in the room, but we're going to be strict with the deadlines on you guys to get this done by June 9th. All right?
We had a meeting on Wednesday. It was particularly unproductive. I don't know if that's really doable.
Well, That's when it's going to have to be done, or the panel will decide. So it's going to have to be done by that date.
Okay.
All right, if there's disagreement, we'll decide. But,
Right.
but we don't want to hear, we didn't have a chance to meet before June 9th.
No, we've met.
So decide, okay?
We've met. I didn't think that it was particularly productive, and I don't know if it's going to be productive. We can try meeting again, and if nothing comes up, then we'll give it to you.
Okay. All right.
The last proposal is a proposal that the Commonwealth has put together, not just for this bargaining unit, for other bargaining units in some fashion or form, to address, again, the problems that exist with a budget deficit, and specifically to a dire budget deficit. And this is not something that the Commonwealth has just dreamed up here. This is taken from concepts developed from other states over the last several years. As we all know, the current fiscal problems the entire country has been facing. So I'll read through this quickly and then provide responses if necessary. What we're asking for is language that provides that triggered by an executive order of the governor based on dire fiscal conditions, that up to 5 days in a fiscal year, okay, either full or partial shifts, and it's equitably distributed across the bargaining unit, those 5 days would be the equivalent of 5 unpaid days, okay?
5 furlough days. But
5 furlough
what's commonly referred to as furlough.
Correct. And prior to implementing such plan, we will meet and discuss with the association.
Association have questions?
Sure. My first question is, how and who defines what a dire fiscal condition is?
Well, I would say based on the proposal, it's an executive order determined by the governor.
Okay.
So this would not, maybe I'll clarify, that this is not a proposal that would give any specific agency the authority to say they want to implement this to save their budget. This is when somebody like the current governor is faced with a $4 billion deficit, find a way to save money and balance the budget.
So there would be no way to say for the union to ask that a neutral arbitrator or a mediator come in to make a determination whether in fact there is a dire fiscal condition. The governor has the outright ability to make that determination. Now, I'm just trying to keep score here. We talked earlier about the wages that over 4 years equal only an increase of 2%. We talked about longevity being eliminated for 4 years. We talked about health care increasing for somebody at $50,000 receiving family benefits from $37 a paycheck to $102 a paycheck. We talked about leave being paid at only 70%. We talked about bereavement days of 3 days being eliminated. We talked about the stress day being eliminated. We talked about limiting overtime to certain circumstances. And we talked about eliminating shift differential. On top of all that, and I probably missed something, I'm sure I did. On top of that, now we're asking this panel to give the Commonwealth the unlimited right to take away a full week's pay.
Again, based on dire fiscal conditions. This is not a proposal that I would say, in behalf of the Commonwealth, we want to impose, but we would like the flexibility given economic conditions.
That's all I have.
Any questions from the Commonwealth?
No questions.
So what we would be telling people is that we have the authority to tell you stay home for 5 days, right?
Or the equivalent of.
Or the equivalent of. I thought in one of your earlier proposals, we're trying to say that we want people to come to work. Okay. Makes sense. Thank you.
Anything else, Brian?
I think that wraps it up.
Anything else from the Commonwealth?
Only our closing, if we could take a 10-minute break.
Let's do that. We'll